You may proceed. Reserve rebuttal time.
Yes, Your Honor, I'd like to reserve 5 minutes, please. Thank you. Good morning, may it please the court. My name is Jennifer Gutmore, and I'm an assistant Lee County attorney here to represent the appellant Lee County, Florida, who is also the plaintiff at the matter below. Lee County is appealing the denial of a temporary injunction because the evidence presented at the injunction hearing that the appellees had been in continuous violation of their zoning restrictions on the property at issue and had a nuisance accumulation on the property was solely unrebutted at the injunction hearing.
Before
Yes.
you get into your argument, even though the settlement agreement provided that it was to be completed by April 2022, I assume this is not new. This is still ongoing.
That's correct, Your Honor. I actually drove by on the way up from Fort Myers yesterday. It is not moot. It would have been a difficult thing to kind of supplement the record, but I don't believe that the appellees will contest that there's still a considerable mountain of horticultural waste on the property as of today's date. Thank you, Your Honor. The second point why Lee County is appealing the denial.
Well, to that point,
Yes.
to the extent that we agree with the trial court that an injunction at the time of the hearing was not appropriate, shouldn't have been entered, nothing would preclude the county from bringing a new motion for temporary injunction based on additional facts.
I suppose the county wouldn't be precluded. We did in fact file an amended motion for reconsideration of the order entering the denial based on the expiration of that. So that is something that's out there. Unfortunately, we couldn't get that scheduled until July. So it's actually after oral argument in this case. But
My point being is that if we do not find the facts that were sufficient here to rise to the level of an injunction, but later there were facts like the fires, there were additional fires that had occurred and shut down the interstate or whatever, but if there were circumstances like that that did occur later on, nothing would prevent the county from seeking an injunction at that time.
I don't believe so, Your Honor, but I do have one thing that would give the county pause about going in front of the same trial court again, is that the record is clear that this trial court focused on improper factors.
Well, he seemed to come to the conclusion that there was really no way he could fashion a remedy. He didn't hear enough to be able to say, yes, get out there and fix this within 30 days.
The only reason stated on the record, you're right, Your Honor, was that he couldn't fashion a remedy and that the county didn't present enough evidence about how quickly it could be
Is there
cleaned.
anything in the record to indicate that the cleanup could have been done and should be being done more quickly than it is?
Well, there wasn't, if I may have a moment, Your Honor, I did bring some of that in my reply brief. There was testimony from several of the witnesses on cross-examination that said, well, I don't know how quickly this can be done. We don't have a per se date or a time period when the county could clean it up themselves. But every one of the witnesses conceded that it could have been done more quickly than the very slow pace that MW is engaged in at the time. It's typically done with one excavator at the time. Ms. Damron, who was our citizen witness who testified, saying anybody could do this quicker than what MW is doing. It's been years now. I believe the fire chief actually had said, well, it's all about how much time and energy and resources you put at this to clean it up. The witnesses.
None of that really sounds like a definite plan. And I think the court, in reviewing the transcript, the concern that the court had is the remedy that the county was seeking, which was no further additional material, which there didn't appear to be any further additional material being placed. And then there was removing within the 30 days, and the court got hung up on, well, what is the offer being made by the county and the evidence, is there competent substantial evidence there that this can actually be done within the 30 days. And so from our perspective, how can we find that what the court did was an abuse of discretion?
What is the county's position that the actual length of time, that the actual remedy itself is really only a consideration that's relevant and necessary after the court examines and determines that there's an entitlement to relief. I made the argument at the injunction hearing that it's.
Part and parcel of that is you have to show that if the materials aren't cleaned up within, say, 30 days, then there's going to be irreparable harm. How would there be irreparable harm? Let's say it's 60 days, irreparable.
Well, the irreparable harm prong, Your Honor, actually is presumed in the county's favor because the county is seeking to enforce a police power. Going back to the Miami-Dade case and through the cases of this court, of the Ware case and the Manatee County case, it's clear that the county doesn't have the burden of proving that the irreparable harm is presumed and that the unavailability of an adequate remedy is presumed. So that actually we didn't present on that topic because we didn't have the legal burden to do so. I don't know if that answered the question. I don't believe it did. I apologize. I'll try.
Just by the mere fact that it's the county filing the claim doesn't mean that it's automatically irreparable harm.
Well, I believe that with that, I do believe that the county did meet that burden of the irreparable harm. We had the
There's
testimony.
still a burden. You can't just say we're filing the claim, and by the way, it's irreparable. If you don't grant it, we'll be irreparably harmed. That's all we're going to say about that.
I think the record was full of evidence about the complaints of the citizens, the complaints of the neighboring businesses, the woman who's in her 80s who has lived there with all these fires for all these years, and the 138 fires over a 4-year period to show that there's irreparable harm to the community.
But all of that happened, how much length of time prior to when the injunction was sought?
That is one of our exhibits, Your Honor. It is in the appendix. Yes, Your Honor. It is in appendix pages 443 to 446. The earliest dates go back to 2016, and at the
What is the most recent in time to the time that the motion was filed?
it was Halloween 2021, and the injunction hearing was on December 10th, 2021.
Now, as far as the presumption, there's been your colleagues on the other side are arguing that you're not entitled to presumption because this isn't an act of police power. Is that right?
I don't believe that was their argument. They might be able to
Well,
clarify that.
That they're arguing that you have to provide evidence of irreparable harm.
Yes.
And you're arguing that you don't.
Well, Your Honor, the case law on this topic, again, says that it is presumed when a county is seeking
And my
to enforce.
question to that is, does it matter that in the cases that you're citing, that those are where someone hasn't even obtained a permit or haven't gone through the process, whereas this is more of a violation of a permitted use that maybe perhaps is going beyond the scope of what they were supposed to, what they were allowed to do?
The cases that we've cited in our brief, one of them, the Manatee County case, is a zoning violation case, which goes into amplified music at a waterfront restaurant. The Ware case was about an unpermitted Quonset that was built in violation of the building code. The Despodo case was about an unpermitted 130-foot radio tower that was erected without permits and not in conformance with the zoning for the property. And on all of those cases, almost every single one is actually from this court on cases involving zoning violations and building code violations. And this court has said that the irreparable harm and inadequate remedy at law is presumed.
But those all involved ongoing violations, didn't they? And that's a big distinction. Did any of those cases involve parties who were already taking active steps to remediate the harm?
They were, but it's the county's position that these appellees are continually violating the property by not cleaning it. While they have a settlement agreement to clean the property, very little has happened. That settlement was happened last July. Very little has happened. We had the volumetric surveys to show that only 2% was removed in a 4-month period, despite their agreement, which requires 11% per month.
And that's with respect to the settlement agreement, but can I go back to the amendment that they were authorized to do, which is, it talks about the storage, the open storage.
Yes.
It says something about the height of the landscape waste materials limited to 35 feet.
Yes.
So is there anything in the record that shows I've seen the volume, I've seen the length, I've seen the width, I've seen the piles. Has anyone brought it back to the amendment to say how high any of these piles are? I saw something in the transcript, as high as a mature tree.
Right.
What kind of mature tree? How tall is that?
Right.
You know, I don't know. And so if I'm hearing correctly, what's going on is the county is upset with the slowness of the cleanup, but I'm still trying to figure out whether that violates what their use was.
Our main contention, Lee County's main contention, isn't about the pile height. It is very clear from the zoning that these landowners and their tenants are only allowed to have horticultural material at all if it's being used as a transfer station. And what it says about transfer station is that it's brought there only by yard waste landscapers and being transferred right away to their other location. It is not meant to sit there for long term. It is not meant to compost. And you can see from the aerials, and as is evidenced by the fires and the complaints by everyone living and working in that area, that because it's composting is why it's catching on fire. It's the county's position that it's never been properly used as a transfer station since it started operation. It's always been piled high with mountains of horticultural waste.
Was some of that though a result of the hurricane that happened during that time? I mean, isn't that when some of it started getting probably out of hand from what I can tell from the record?
That point, Your Honor, was raised in the brief of the appellee MW. And it was not fully fleshed out at the hearing because Hurricane Irma, this is outside of the record documents, it's only a little bit.
Go by the record, but I saw something from the DEP, the administrative hearing, and some of the findings that were made in that had to do with the hurricane and some of their stockpiles.
The special exception that was granted to MW Horticulture that was okayed by their landlord -40 was that they could store Hurricane Irma debris specifically on tract D of the property, which is the south side of the lake. This injunction focuses on tract A, which is the north side of the lake. So tract A was a problem well before Hurricane Irma. We've got photographic evidence to demonstrate that. We've got fires that predate Hurricane Irma in September 2017 on our chart from the fire department. And the other thing in the chart from the fire department is it segregates between fires on tract A, which is not Hurricane Irma related. It predated it. You can see that from the aerial photos, and the problems on tract D. And tract D was specifically allowed to have the accumulation after Hurricane Irma. So while
was an injunction sought before the one that we're dealing with now?
on which tract, Your Honor?
On tract A, that's the tract A.
So this is our fourth motion for injunctive relief. The first motion was filed in March or May 2020. Because of the pandemic, it wasn't set for hearing until August of 2020. Immediately prior to that injunction hearing, there was a site inspection between members of our staff and members of MW Horticulture staff. Somebody was actually sick with COVID. So because all of the witnesses were exposed at that site inspection, the August 2020 injunction hearing was canceled. And actually, now that I'm talking through this, I need to jump back one moment. The initial motion for injunctive relief filed by the county was set for hearing and was continued because MW's initial counsel obtained leave of court to withdraw his counsel. So that's the reason why the initial injunction was canceled. Give me 1 minute. I actually have those dates. Yes, that's correct. February 22nd, February 24th, 2020, the initial injunction hearing was canceled because counsel for MW Horticulture obtained leave to withdraw from the case. Lee County filed their second amended motion for an injunction in May of 2020. That was set for August 2020. That was continued because of an emergency contamination of COVID-19. We had a third motion for injunctive relief that was filed in May 2021 that was set. It was canceled because the trial court granted the appellee's motion to dismiss. The court ordered the county to simplify the complaint. The county did that. We filed it again in June, on June 4th, 2021. That was initially set for the end of August 2021. It was continued because the principals and the only witnesses for MW Horticulture were hospitalized with COVID-19 at that point. So this.
So you're at your 5 minutes if you want. You can keep going if you like, but you're at your 5 minutes.
Your Honor, I think it'd be better to reserve my 5 minutes if that's okay with the court.
Okay with us.
Thank you very much.
Thank you.
May it please the court, Dan Fleming on behalf of -40, I think you're kind of close. I'm going to start with one of the questions you asked, and I think it just goes to, it's precisely the issue you're reviewing here, is what Judge Fuller did with this temporary injunction request at the time of the hearing. You just heard an argument, and you see in their brief, and I'm quoting from their brief on page, this is in their reply brief, where they indicate that all of the hearing witnesses opined that any, and this went to one of Judge Smith's questions to counsel a second ago, that all of the hearing witnesses opined that any entity could clean up the property quicker than MW Horticulture. That is reflected in page 6 of the reply brief. That blinks reality. I'm going to read from you just a couple of really short excerpts of the testimony that actually came in that Judge Fuller actually considered. And I think it becomes crystal clear that the decision he made was based on the evidence that was presented, not on the argument that you just heard, which is completely unsupported, if not completely contradicted by the testimony that was provided at the hearing. This is at page 79 of the hearing transcript. The question I'm asking, there were only 2 witnesses, 2, that could even address the issue of whether or not MW Horticulture was not doing it fast enough, or that Lee County could do anything different or improve on the situation regarding safety, pile heights, fires, anything. 2. One was Mr. Loveland, who's a Lee County employee. The other one was Chief Underwood, the fire chief. And their testimony, again, it can't be much clearer. The other 2 things the council was asking, this is at page 79, line 21. For in this temporary injunction is to enjoin the defendants to remove all the debris from track A within 30 days. And this is what I asked. Is there anything in your education, training, or experience, Mr. Loveland, that would allow you to give an opinion to this court as to how long it will take anybody to remove the debris that is currently on track A of this property? Answer, no. As I indicated in response to the previous question, other county departments are assessing what it would take to remove the material. That's the closest they got to it. But I also asked, just to be clear, I also asked Chief Underwood at page 157. And again, this testimony, again, the contention by the county that there was literally all the witnesses testified that it could be done faster than MW, again, to use the phrase again, blinks reality. This is the testimony that was provided to Judge Fuller. Given the fact that you have not received that information from the county, let me make sure I'm clear. You don't know how long it would take the county if they were, as the court is being asked to rule, if they were allowed to go in and do it themselves. You don't know how long that would take specifically. Answer, no, sir. That's not my field of expertise. That is the sum substance of the two witnesses that the county brought before Judge Fuller and then asked for a temporary injunction. I mean, it literally couldn't be any clearer that the record was completely devoid of any evidence from which Judge Fuller can rule. And you saw that in the finding that the judge made. He said that the contention, and it goes even beyond the absence of evidence to show that they could do it better. The judge specifically found in his ruling that it was painfully unreasonable, the request to do it in 30 days. That's the evidence. The judge listened to all the evidence in the case, everybody who testified, and Judge Fuller came to the conclusion that it was painfully unreasonable what the county was requesting these entities to do. But to go back and give some context to the entirety of the situation, this is a situation, make no mistake about it, this didn't even become a litigation until well after Hurricane Irma. I mean, they're talking about a request for a temporary injunction. None of that was brought to fruition. None of it got to a court until well after that. The county has not established, again, they did not and cannot show a temporary injunction would be in the clear public interest. I mean, that's the bottom line relative to what you have to decide here today. The county has not established any evidence indicating it would be able to remove the materials on the property more quickly than MW, or that would make the property safer anyway. The debris and the waste contained within the North Yard piles is the direct consequence of Hurricane Irma. Hurricane Irma was the major hurricane in 2017. Hurricane Irma made it difficult for the local municipalities, including Lee County, to manage the organic debris. In a July 14th, 2021 agreement that was entered into between my client and Mr. Middleburg's, and we begged the county to be part of it. And you saw Judge Fuller's, we begged him, go into the, look, we're trying to do everything you do. And Judge, your question about weren't those other cases, and it's a complete misapplication of the law to look at any of those cases, because in every single one of those, as the question you asked pointed out, every single one of those cases, the entities that the temporary injunction was sought against were continuing to breach and break the ordinance that was going on. Here, the parties have contractually obligated themselves to clean up and remove the waste. And there's been no evidence that they could do it any faster than they're doing it. That is a completely, those cases couldn't be less analogous when you look at what the findings are. And what, if you look at the Manatee County case that they actually cite in their brief, again, you end up with, find that one spot. In the Manatee County case, again, it looks at, and I'm quoting from their brief, given the unusual background facts and multiple factual questions that exist in this case, the trial court should have granted, this is what they're saying in Manatee County, this is the case they cited for this court to tell you should reverse Judge Fuller and grant a temporary injunction should have been granted. They found the trial court should have granted the injunction in Manatee County case to maintain the status quo between the parties while they litigate the constitutionality of the property zoning. That's not the facts here. The facts here, there's nobody that is, there's no, they haven't even requested, their temporary injunction does not request anything regarding the status quo. In fact, the agreement that was entered into between the parties that we begged Lee County to participate in is preserving the status quo. No, and the uncontroverted facts that were established at the hearing before Judge Fuller established, again, without anybody contradicting it, that no material has been brought, no debris has been brought on this property since September of 2020, zero. And that every single aspect of the case relative to the fires, you go back and look at when the worst fires were, they're all before. We asked Chief Underwood about the calls, what's been going on. And there was literally no evidence presented to Judge Fuller that would create any kind of irreparable harm to your question, Judge Black. There is no evidence. And Judge Fuller was at a complete loss. In fact, Judge Fuller specifically, in light of the agreement and the fact that we begged Lee County to be part of it, he told the county at the hearing, if you'd enter into the agreement, then I would have the ability as a party to the agreement to enforce aspects of the agreement in the county's benefit. The very thing you hear the county complaining about here today does not justify a temporary injunction. It would, however, provide them, and again, this goes to, again, what the case law talks about. Are there other remedies available? Clearly, there's another remedy. Judge Fuller did everything but draw him up a roadmap and told him, look, if you had been a party to the contract, I could enforce the contract to your liking. You're not a party to the contract, despite our requesting them to do so. And they could be in here, sitting here, which is what they're now arguing to you. Look, they haven't done what they said in the contract. They're not doing it as fast as they said they were going to. But guess what? Lee County decided not to go down that path. We told them, look, you're asking for a temporary injunction that we've already given you. We've already agreed to remove the debris. We've already agreed that, and my client, and just so the court understands, my client is not just sitting on the sidelines. No, they're not the ones actively removing the debris from the site. MW is doing that. But my client is foregoing hundreds of thousands of dollars in rent to incentivize Mr. Middleburg's client to remove that debris. So again, these parties, you got two parties that are acting rationally and certainly in compliance with regard to the law as it pertains to temporary injunctions. This judge had absolutely no evidence to grant a temporary injunction based on the record that was before him, and nor does this court have any evidence from which to reverse that ruling at this stage. And unfortunately, the relief you're being asked to talk about, the relief the county is talking about now is regarding an agreement that they elected not to be a party to. So again, I'll defer now to Mr. Middleburg. I think he's got some more additional information to add. Unless there are any questions, I'll see my time, Mr. Middleburg. Thank you.
Good morning. If you will please the court, my name is Barry Middleburg and I represent the MW defendants. Rather than rehash the arguments that were made by counsel for -40, I would just like to reiterate certain issues that may have been glossed over. If MW had continued to take horticultural waste onto the property as a transfer station, then Lee County would have an argument to make, but they have not. It has been more than 1 year since any new horticultural waste has been taken onto that property. If MW continued to grind the piles in violation of the statutes, then the county would have an argument. But it has been over a year since any grinding has occurred on this property. If the county was able to come forth and say there is a better way to do this, there is a better and faster and more expeditious manner in which to clean the property, then the county would have an argument. But all of those elements were missing at the hearing in which Judge Fuller denied the motion for a temporary injunction. The purpose of that temporary injunction was to maintain the status quo. And the status quo on this property is being maintained. There is no horticultural waste being deposited on that property. There is no grinding being done on that property.
You don't dispute that that was all being done previously, that MW previously was in violation?
MW became in violation when they took horticultural waste onto the property as a result of the hurricane, and they stockpiled the horticultural waste on that property. Yes, that put them in violation. Okay, they operated 2 tracks, A and D. D has been totally cleaned up. That track was subject to Lee County having issues with it, and MW went through that and cleaned up that property and took everything off and hauled everything off at their own expenses so that the county would have no expense whatsoever in cleaning track D. They remain on track A and they remain dedicated to cleaning that property up. They could walk off that property if they wanted to. Okay, MW North is the landlord on that, is the tenant on that property, and they can walk off, but they are there. They are cleaning that property, they are reducing the piles, and they are reducing them as safely and expeditiously as they can. And there has been absolutely no testimony at any hearing of a better fashion to remove these piles than what is being done right now. So if the purpose of a temporary restraining order, injunction is to maintain the status quo, then the status quo is being maintained. Now, when the time the settlement agreement was entered into between the landlord, -40, and my client, we presented that settlement agreement. We asked the county, please review this, please make any changes. We invite you to be a party to this. We simply want to get this matter resolved at this point. At that time, they denied entering into it. It was their election not to enter into a settlement agreement that was able to be complied with by all of the parties. At this point, Your Honor, there is nothing that the trial court did not consider at that time. And the trial court's rulings comes with a presumption at this point that should not be overturned absent a violation or an abuse of discretion. None of that is relevant today. We heard 4 hours of testimony, and in that 4 hours of testimony, Your Honor, there was nothing more that was put into the record than the facts that nothing is being put on the property, there's no grinding going on the property, that the piles are being reduced, and the status quo is being maintained. And that is the essence of Judge Fuller's ruling. Thank you.
Thank you, sir. You have about 6 minutes left if you care to use it.
Yes, Your Honor, thank you very much. With respect to the 30 days and where the county based that request, it is based on what is authorized by the Lee County nuisance ordinance. The Lee County nuisance ordinance says that if there's a nuisance accumulation that meets the definition, that endangers public health, safety, and welfare, that the county can elect to go in and immediately abate it. So our nuisance ordinance actually would have allowed the county to go in and immediately abate it. We are allowed under our ordinance to take that immediate action if it meets that criteria. Additionally, where county based this 30 days.
Apply here where you have a permitted use
But
to store certain material.
It's the county's position, Your Honor, that this is not a permitted use because the material is never moving from the site. It is dumped and it is sat there for 5 years.
But it is moving because there was evidence it was moving off.
That is only evidence that is alleged to have started happening as a result of their settlement agreement.
Well, whatever the result was or what caused it to be moved, we can't ignore the fact that it is moving.
It is moving ever so slightly. And it's the county's position that as the property sits, it is not in compliance with the zoning. It never should have been there. It's been there for years. The additional basis where the county actually made this demand is set forth and described in Florida Statute 162.213B. That actually is a section of Florida statutes which gives the county supplemental authority to enforce its code enforcement provisions that the county is allowed to adopt. And under Section 3B, an owner can be given no more than 30 days to abate a code enforcement violation unless there's a danger to public health, safety, and welfare. So again, 162.21 allows the county to take these actions and say, you can have 30 days to clean it up, owner, but no more than 30 days. But if there's an immediate danger to public health, safety, and welfare, the county can step in and take action.
But doesn't that assume that it can actually be done within 30 days? It seems, I mean, sure, you've got a statute, but you also have like the laws of physics. So if it's physically impossible to do it within 30 days, then what happens?
Well, the process would have been that they start complying with it, and if they do clean it up, they could go ahead and seek to have that mitigated. But it's simply having one excavator and one truck come in on a daily basis that's been sporadic and intermittent is just not It's just not in compliance. It's just not enough.
But wasn't there some evidence that they have to be cautious, which would require weighing the public health of not moving it too fast for there to be fires? I mean, wouldn't that, right?
Your Honor, that
So
was,
did the county present any evidence that they could do it faster, or how they could do it faster without subjecting more fires or causing more fires? Because that's where I don't see that from the record.
the first time that argument was presented was in the briefs filed before this court by the appellees. There was no testimony about that at all at the hearing.
But there was record evidence that this slowness of the cleanup or the removal was because of some smoke that they were trying to be cautious about. Am I not correct on that?
No, Your Honor, I don't recall that there was ever testimony presented about that at the hearing. The danger argument that the appellees needed more time because it was going to spontaneous combust was not testimony that was presented or in an exhibit that was presented at the hearing.
I think, wasn't there testimony that they have to be cautious in cleaning up because of some of the fires though? I mean, maybe I'm drawing some connections as a result of what the testimony was, but are there these stockpiles can cause fire or smoke, right?
They are smoking, yes, that's correct.
And can they just go in and take, I mean, if they could go in and just take them, I didn't see any evidence that that could be done. And there's a reason why they're slowly doing it.
There was testimony from the fire chief, Underwood, talking about that this could be done. He talked about another company that had done it on another piece of property where if you could break it apart, douse it with fire, he's seen it done rather expeditiously. So in terms of the danger, actually, it was refuted by one of the county's witnesses on cross-examination pursuant to the appellee's questions that this can be done safely. And there was no affirmative evidence brought forth by the appellees to show that it wouldn't be safe. There's just speculation on their part.
You may wrap up your arguments, you're just about out of time.
The points that I want to end on, thank you, Your Honor, is that there's been a lot of arguments presented today by the appellees that the county's declination of entering into this settlement between the appellees is something that should really draw the court's attention in terms of the entitlement to injunctive relief. The county actually didn't know that there was a settlement that had been entered until it was provided as an exhibit to their responses to the injunction a month afterwards when it was filed with the clerk of court. Additionally, if you follow that argument, the appellees are suggesting that the only way that a county can enforce its ordinances if the county enters the settlement, that would deem the entire permitting, zoning, and code enforcement process useless. There would be no point of a contested code enforcement hearing if the county can only enforce its laws if it's in agreement with the two parties alleged of violating those ordinances. It's the county's position that the refusal to join the settlement should not have any emphasis placed on that argument. With that, Your Honor, I will conclude with our prayer for relief that Lee County is respectfully requesting a decision from this court reversing the order denying the temporary injunction below, and that the trial court be directed to allow Lee County to enter the property and clean it up as it has the right to do so under our ordinance. Thank you very much, Your Honor. Have a great day.
Thank you very much. That concludes court this morning. We are in recess.
All rise.